Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. Today is August 10th, 2017. This is our bi weekly, every other Thursday telephone call for the community. We answer the questions that you've posted. I went over the questions really quickly. I didn't see anything that stuck out as a frequently asked questions. So these are just routine questions which we'll go over one by one. The first question is about traveling when your 485 is pending. So DSM 918 says my current EAD is expiring Jan 2018. Looks like under 485. So the lawyer says you shouldn't travel while the EAD extension is pending now. I don't know where they get that from. If you already have an advance parole approved, you apply for an EAD extension and leave, and you come back within the life of your current advance parole, there is no problem. I don't see what the issue is. The second thing is, can you apply 180 days ahead of time, or do you have to wait 120 days? The answer is 180 days. These are the new regulations starting January 17th. Tell your lawyers to read the new regulations. They are actually also on our website. Easiest thing to do is you can just go to, let's see, my blog. If you go to my blog and you scroll down to, here is the entry, EAD regulations effective 17 January 2017. And I have a chart drawn that basically explains the way the regulations work. Okay, so this is right here is your information that you're looking for. You can take a look at that, have your lawyers take a look at that, or just look at the Code of Federal Regulations. I think those are the only questions you have. Oh, the third question you have is, am I entitled to automatic EAD extension? The answer is yes. If you apply for your EAD renewal and you are a 485 applicant, you can continue working up to 180 days even after your current EAD expires. Star 5 if you have a follow-up question on this. Star 5. Star 5 if you have a follow-up question. Okay. There's one. Let's get that. Pennsylvania, go ahead please. Pennsylvania.
Yeah, hi Rajiv. Just wanted to confirm, isn't it dependent on the category?
Yes.
It has to be a C
Yes.
or 9 category.
That's right. It is dependent because here he has written clearly it's a C9 category.
Okay. And I just joined the call. Sorry, I was a minute late, so I missed the answer to question 2. Could you just repeat that answer for the second question?
I have no problem with somebody traveling if their advance parole is valid. The fact that their EAD extension is pending, there's no problem with traveling.
Oh, okay, so I'm not sure why they brought it up. That was the only concern, kind of tying me up to stay in the US. They said...
Makes no sense to me.
Sorry, go ahead.
That's a very mysterious pronouncement. That makes no sense to me.
Okay, thank you.
Okay, you're welcome. Bye-bye. Okay, so then we come to Ram, Catchram 12. I had the following questions. Can the company file H-1B based on approved I-140? Of course. I have my priority date of 2010 on EB2. Where can I find the most updated information on when my PD might get current? Well, you can go to the visa bulletin. We have the visa bulletin on our website, and we have the archives of going back quite a few years, all the visa bulletins. You can kind of see what the date movement is like. So you can go to immigration.com/visa-bulletin. Also, you can find it through our footer. If you go to the footers, under the common topics, there is, let's see, what happened? I'm lost here. Contact processing times and status checks. I believe that's where your visa bulletin is. Also in the drop down list on the top, popular information, there is visa bulletin right here. So you can go there as well. That will tell you what the movement is like. You say I have my priority date of 2010 on EB2. Okay, then I'm on L1B and transferred to US couple of years back. My question is, should the employment in India be valid open during my stay in the US? No, no. The law is that the businesses must continue to exist. So if you worked for a company X India and you came to company X USA, X India must stay in operation. Your job can be given to somebody else, or it can be closed. Can the company still file L1A provided the criteria are met? Yes, absolutely. Keeping the job open has no bearing on your eligibility for L1A if you qualify for L1A. Star 5 if you have a follow-up question on this, star 5. Okay, that was a relatively easy set of questions. Then we come to Jane USA 99. How much time for prevailing wages in Illinois? I think it's about 3 months. Let me double check.
This is not a valid menu option.
Samanji, how much time for prevailing wages these days? Approximately 3 months. So, okay, and the way we do it is we start the advertising, and we've never had a problem with prevailing wages expiring. I think they give it for minimum 90 days and up to, is it 1 or 2 years, something like that. Let me double check that also.
This is not a valid menu option.
How much time do they have the validity for these days, prevailing wage? June 30th of next year. Only the problem is around July when they are doing the new surveys. Okay, all right, bye. So anybody who applies after July of any year, you'll probably get it all the way to the next year, because every July, or at least most Julys, Department of Labor updates their wages. So as long as your company is okay with a possible level 4, they can start advertising, or at least they can put in the some of the advertising, the one that doesn't cost them. So you said, your HR said they can't file perm preparation parallel. They can start the perm preparation. I think it should be done in good faith. If your company is okay with level 4 wage, let's say if your job is a physician or a developer, we know that this position is going to be classified as a physician or classified as a developer. So, and if you are EB2, you're probably level 4 salary. Company is okay with that, they can start advertising in parallel. I don't see any problem. Star 5 if you have a follow-up question. Star 5. Okay, next question. Again, Jan US 99. I recently joined my client full-time, and they've try to keep it to one question, guys. I recently joined my client full-time, and they have transferred my H1B, and H1 is valid till Feb 2020. I'm planning to visit India, and I need to go for visa stamping in October 2017. Are there any issues with H1B visa stamping? No large scale rejections, but yeah, definitely visa stamping for H1 is always problematic, especially so if you are working for a third party instead of working directly for your own client, for your own employer. If it's not an in-house employment, it becomes subject to questions. What documents do you need to carry? You realize that the consulate has a complete copy of your petition in the PIMS database. So you can carry a copy of the petition, you can carry copies of your pay stubs, of course a letter verifying the employment. Your lawyer should know all that. Are there any standard questions to prepare for stamping? I don't have any standard questions. Each case is different. Star 5 if you have a follow-up question. Star 5. Okay, let's go to Arjun, Arjun G, I guess. Thanks for your okay. I'm a U.S. permanent resident working in the U.S. Wants to get married. Family-based category can take time. I want to live together with my wife. After my marriage, ask my wife to apply for a tourist visa. First of all, when she applies for a tourist visa, on the forms, she has to reveal that her husband or her fiance lives in the United States. That immediately drops down drastically her chances of getting a tourist visa. It's not a complete bar. She can try. I'm not saying that she can't try. But chances of getting a tourist visa when a green card is going on are rather dismal. If she travels, okay, then let's say she gets a visa. When she lands at the airport, they're going to ask her, why are you here? I had a call like this just about an hour ago. It was a consultation. And one of the questions asked was, well, my sister lives here and my husband would live here. Can I not say at the airport that I'm coming to visit my sister? I said, well, that's a lie. That's a misrepresentation, because really you are coming to visit your husband. You might also be coming to visit your sister. If not a lie, it is at least concealment, active concealment. So I would be very concerned about a statement like that. So when she lands at the airport and she says, well, I have come to visit my husband, that is the second point of failure. The first point of failure is the visa. Second point of failure could be the Customs and Border Protection. They could tell her why you can't come in. After 1 year, I would get a job in India, relocate to India with my wife. That sounds all right. Only after my, I guess, priority date reaches to India after 1 year. I'm not sure what you're saying here. Okay, so you've got a couple of complicated issues here. You are a green card holder. For you to leave the United States, you yourself need permission on good basis, because if you stay away from USA too long, you lose your green card unless you have a re-entry permit. So look into N470 and I-131, both of them, because if possible, you should preserve your right to naturalization as well, which is done through N470. I think the best thing for somebody like you would be either have your wife come in on a visa which is immune to the green card problem, such as an H1 or an L1, or if she wants to go to school, she could come on a student visa, and then you could get married. Of course, not as a pre-planned thing, but if she comes here and after a few months you decide you want to get married, but she'll have trouble traveling after that. So really the best thing to do is an H1 or an L1. Those are the two visas, or O1 of course if she qualifies. So some visas are immune from the problem of green card pendency. That's the best way to handle it. Star 5 if you have a follow-up question, star 5. Arjun, if you're here, star 5. Okay. Let's go on to the next one, SK 2008. My priority date is 2009. EAD since 2012, maintaining H1B, not used EAD. Now I want to use EAD. Can I work for any company on hourly W-2? Of course you can. When USCIS issues RFE for employment verification letter, is it okay if my company provides the W-2 hourly rate? And see, if you are planning to just change companies, you have to file supplement J to get advantage of AC-21. Okay, I'm assuming that your 485 has been pending for a while, more than 180 days, and I-140 is approved. So in order for you to take advantage of AC-21, you've got to file supplement J. I don't have any problem with people getting hourly salary. Just make sure that the job is committing to a full-time position. Then I don't see any issues. I usually also advise people to keep their H1 active, because you never know how things are going to work out tomorrow. Something goes wrong with the 485, at least you have no interruption on continuing to work while you have your H1 still in hand. So I like that idea. Of course, if you can't do a concurrent H1 for another employer or a complete move over of an H1, then you can use the EAD. And if you have to come back on an H1, you have to go outside USA and come back in. That's the way EAD works, whether it's regular EAD or EAD under compelling circumstances. All EADs are going to work like that. Star 5 if you have follow-up questions, star 5. Okay. I would appreciate if you don't post links to other lawyers' websites. I get very nervous about that because I don't know what anybody's writing. In fact, the link that you had posted, and this is the next Jan, again, this is the third question from Jan US 99. I don't know what you're talking about, but there are no earth-shattering changes that I know of to labor condition application forms. Government was proposing changes that reflect the regulations in the forms themselves. I don't see that as an issue. I'm not sure where the concern is. Point system. How will the point system affect you? Well, it's too early for me to start commenting about legislation which is still pending. Remember a few years ago when Senate passed a 1100-page bill, we spent hours upon hours studying it, and then it failed at the House level. It was never passed. That too had a point system. So I don't know if I want to even connect with that right now. I have a radio show that I'm supposed to do this weekend, so I might save a recording where I'll talk about the point system. Idea is you reach a certain number of points, we put you in a pool, then we pull the top people from the pool. So the point system is to qualify you to get in the pool, but then how many points you have will decide who the top people are and who will get the green card. So it's kind of a two-step system. I'm not sure it's the best thing for us, but that's what they are thinking. I'm not sure it's going to go anywhere. Frankly, Trump has no political goodwill. All Democrats are going to oppose this bill. I can see that happening. Many Republicans don't like it either. You've seen what happened to the health care. They tried to push in the Trump care bill. That didn't go anywhere. We came close to it. Unfortunately, it's just a. But politics aside, the fact of the matter is I'm not sure how far this immigration bill is going to go. Star 5 if you have a follow-up question. Star 5. Okay. Next question is from Naveen New. I have an approved I-140. For I-485, how I could change adjustment of status to consular processing? Okay, what I'm assuming you're saying is this. You have an approved I-140 and I think you're outside USA, Naveen. In order for you to convert to 485, you've got to be inside USA in a legal status like H1, not a tourist visa. I think that's a bad idea. On H1, L1, H4, L2, and then you can just apply for 485. You don't need to do any additional paperwork. When you convert from 485 to consular processing, you need additional paperwork, but not the other way around. You just need to be here on a legal visa that allows you to file adjustment of status. Star 5 if you have a follow-up question on this. Star 5, okay. Vaibhavi Parekh says, my colleague is a US citizen. She's battling an aggressive form of cancer. I am very sorry to hear that. Invited her fiancé on K1 visa. They got married. Now, 485 is pending. They have an interview with the local USCIS office. My colleague is concerned that they'll deny her for a fiancé's 485 because of her own health condition. No. I see no reason for that. Just because the sponsoring spouse has a serious illness is no ground for denial. As long as there is affidavit of support from her, she's working, she's got the money to support him, or she's got a co-sponsor. The fact that she's battling cancer is not going to be a problem. Not an issue. Okay? Star 5 if you have a follow-up question. Star 5. You can press star 5 on your phone. Okay. Next question is Vijay. JVJ. Says, I'm on H1B. I have EB3 I-140 approved from company A. Right now with company B, who did not file my perm, and they will not in future too. So H1B, EB3 approved I-140 from company A, but working for company B on H1B. They're not going to file green card. Can I work with company B until the dates for filing employment-based visa application is cut? Wait. First of all, The law only requires that you have the good faith intention. This is important to understand, folks. The law only requires that you must have the good faith intention to join your employer upon approval of the green card or before that. Don't have to join before that. You can actually join even after the approval. And interestingly enough, as long as you have the good faith intention, you actually don't even have to join. After 180 days of 485 pendency I-140 approval, you can choose to stay with the same company you are at or with any company as long as 180 days have passed and they file supplement J for you. So you can work for that company as long as you like. The only thing is the company A, the sponsoring company must have a job for you in good faith. You must have the intention to take that job. I've discussed this issue in frequently asked questions many times. So if you go to our frequently asked questions, you will see many recordings of the different angles of this issue. Do you advise me to do the H-1B transfer to company C now? Why do you want to go to company C? Oh, I see. Company C is another company who's willing to do your green card. I always like the idea of having as many safety nets as you can. And personally, not for any of these reasons. These reasons I already explained to you. But in order for you to have another safety net, I think going with a company that's willing to file your green card separately and completely from the ground up, I think it's a good idea. I believe so. Star 5 if you have a follow-up question. Star 5. Okay. Dhruv Parak says, I'm on H-1B. I was working with company A till Feb 17. I-94 expired 9th March 2017. You filed your next H1 one day late. That means you're already accruing unlawful presence beginning 10th March. That's the way I see it. You got denial on 9th May. Filed new petition. You've been accruing unlawful presence since March 2017 when your H1 was denied. No, I'm sorry. When you stopped working for the old employer, and I'm assuming your H1 was revoked effective that date, and you filed your transfer one day too late. So if there is, let's say this is a timeline, okay? Let's say this is a timeline. I'm just pointing to the screen. So if you leave here and it's difficult to point. So if there's a timeline and there's a gap between when you left and got H1 revoked and when you applied for the next H1, then you are probably in unlawful presence. You can't depend upon it. There's a 60-day grace period, but my only issue is, does that apply to you? Were you laid off? It's a very difficult question to judge. Best to assume, assume that you've got your unlawful presence period going since March. Can she apply for B2 visitor visa? Your wife? The problem is once you guys are out of status and already unlawfully present, unless USCIS forgives you in a filing like a B2 filing or a subsequent H1, you are accruing unlawful presence. And by the time you find out whether you've been forgiven or not, it might be too late already. So if they say no, 7 months later, now you're barred for 3 years. And that's the problem. Star 5 if you have a follow-up question on this. Star 5. So somebody's going to have to sit with you and parse through that 60 days, whether that applies. Let's see. One question from Florida. Florida, go ahead, please.
Yes, Rajiv. So, 9th March was, I-94 expired.
Right.
Company didn't revoke, 797 till 22nd March. They revoked on 22nd March.
Then hang on, back up a little bit. Then I would say, but did you get paid all the way to 10th March or no?
Yes.
Okay, if you got paid all the way to 10th March, and your petition was not revoked until the 22nd, because USCIS received your filing, I'm assuming that they received your filing on 10th March, your unlawful presence will begin from 9th May 2017.
9th May 2017, yes. Okay. So, yeah, that's the question I had.
Right, right. So if you have a timely filed petition and your I-94 expires in the meantime, your unlawful presence will begin only upon the denial of the H1. And filing a subsequent H1 is not going to stop that unless you get forgiven, and you won't know if you're forgiven or not until it's too late. So you know what you could do? You could ask for an expedite. Remember, premium processing is not available, but expedite is still available. Okay? So if your daughter has a medical condition, you are in this very strange situation where if your case is not decided within the 180 days, you could be subject to 3-year bar. You want to make sure it gets decided as quickly as possible. I actually just got an H4 EAD, H4 Nunc Pro Tunc expedited. Unusual, they usually don't do it, but if you have good humanitarian considerations, they might be able to expedite it. Okay?
Okay. Thank you, Rajiv.
Oh,
Thank you for your advice.
You're welcome. Good luck.
Thank you.
Okay, so then we go back to Deepthi Kandukuri. I'm on H1B valid till 2017, applied for extension in May 2017. I have an approved I-140 for more than 180 days. Priority date is December 2014 under EB2. I want to change my employer, non-profit organization. So I have a few questions. Does new employer, non-profit organization, have to file new H1B or apply for H1B extension for me? As far as paperwork is concerned, it's pretty much the same thing. But they have to file for an H1B transfer. Once I take the new job, does the new employer need to file green card permanent I-140 again? Yes, they do. Yes, they do. You cannot, see, just because you have an I-140 approval doesn't mean the next employer doesn't have to file a perm again. They have to. Only exemption is if I-140 is approved, 485 has been pending 180 days, you can take a similar job and not have to restart your green card. But if your 485 is not filed and pending 180 days, you've got to start a green card all over again, but you'll carry the priority date of the old case. And because your I-140 is approved, you can keep getting H1 extensions on a 3-yearly basis with any employer. Your priority date will remain the same. Your right to extend your your H1 will remain in place. And yes, even if they file under EB3 and the earlier case was under EB2, priority date would still be transferred. Star 5, Deepthi ji, if you're on the phone. Star 5, if you have a follow-up question. Okay. Next one is from Syed Shahabuddin, who says, it's about citizenship interview in 1 week. Everything seems to be good except number of visits out of USA. I visited India 2 times and Canada 13 times. Duration of visits under 6 months. Purpose of visit was to meet relatives and my son and my family in Canada. Acceptable explanation is exactly what you gave. Always tell the truth. Any lawyer who tells you to make up an explanation which is not true is a criminal. They're not a lawyer. That's a crime. That's called suborning perjury, asking people to lie. Absolutely. If a lawyer tells you to lie, they are a crook. Walk away from that as quickly as possible. Tell the truth. And I don't see any problem as long as your home was in the United States. Genuinely, you work here, you live here, and you occasionally go even for 2-3 months vacations each year. I don't see any problem with that. Star 5 if you have a follow-up question. Star 5. Okay. Next question is from Samir. Immigration Help 2014. I have used, so they've used an accredited representative for filing their I-751, removal of removal of the conditional status from the green card. And they gave the address of, I guess, accredited representative as the physical address because I keep moving. If I move to a different state, I would still continue to keep. You know what you should do? Here is the best thing for you, Samir. Just in general, by the way, the Form G28 and the forms allow us to receive certain documents from our clients. That's new. It didn't used to be like this, but now clients can choose to receive documents at their lawyer's office. You can do that. I think in your case, the best thing would be call the USCIS. It might take you all day to get through. Find out what their answers are. Write them down. The officer who talks with you will give you their badge number or their first name, something like that. Write that down. Write down the name or the badge number, the date and the time of your call and what they said. That will at least protect you from any allegation of wrongdoing. That's what I would advise. Okay? It's not 100% protection, but it's definitely some protection, and it's a good way to go. Last question I have, oh, I'm sorry, star 5 if you have a follow-up question. Star 5. Okay. Last question for today, and then we'll take new questions. We have time today. H-1B aspirant Shankar says, I had my H-1B petition approved in 2016, but I didn't use it. Oh yeah, you sent me an email too. So in your case, what has happened is government has said you are subject to the quota and you are here on H4. If you are subject to the quota, the fact that you have an I-140 approved does not make you cap exempt. If, however, let's see, let me think about this for a minute. Hang on. So cap exemption, the most important thing is you don't have an H-1B petition approved. Therefore, you're always subject to the cap. Yes, you are subject to the cap unless you get a cap exempt job. The I-140 approval does not make you cap exempt if your H-1 was never approved. If, however, you have one unrevoked by USCIS approved H-1 in the last 6 years, you will be quota exempt. Star 5 if you have a follow-up question. Star 5. Okay, we're good. Any new questions? Go ahead. Star 5. 1, 2. Folks, is that it? 2 questions today? Very good. Let's get started with New Hampshire. Go ahead, please. New Hampshire.
Yeah, hi. I have applied for my H1 extension along with H4 and H4 EAD in Feb. It was valid till June 29th, and I got my H1 approval, but H4 is pending under security check. So I have, but I have not heard cases for H4 pending under security check. Do you have any idea usually how long this security check takes? She has been working on H4 EAD before that.
I can make a guess. My guess is sometimes what happens is somebody's background looks like it needs to be investigated. For example, let's say the government has a person of interest named Mayawati, and your wife's name is also Mayawati, and there are a couple of other indicators that seem to suggest it must be the same, or it could be the same person. Then somebody has to go and physically check those records. That can take time. It can take a few weeks to a few months. So it's not impossible. It can happen. Doesn't usually happen, but it can happen. It's nothing to be concerned about. As long as her H4 was timely filed, she has no status issues.
Okay.
So, anything else?
And raising SR or doing anything will not, there's no way to expedite the process, right?
The way I look at it, what is the harm in asking? You can ask.
Okay. Yeah.
Okay.
Thank you.
Good luck. Okay, let me go on to the next person. This is an anonymous, so it's probably a voice over IP. Go ahead. Go ahead with your question, please.
Hi, my question, sir, is that my employer stopped. I'm on an H1 My employer stopped paying me since April this year because there was no work, and I have been looking for jobs and I am searching projects. However, now the situation has become where they have said to me that it is better that you go back to your country and we will see later on. And last year they changed the W2 amount from for about 10,000 they reduced for some reason, and don't have any, I haven't given any permission. They didn't ask me. Nothing was consulted. They just changed the entire W2. The difference of the amount, only for that amount, they have generated the paychecks for this year until April. After that, they have not generated anything. And this year they haven't paid me. And for last year also, even the reduced amount, they have paid me lesser than that. Now, I have filed a WH4 complaint.
You have to.
With WH.
Yeah, you have to.
Yeah,
You have to file a complaint with the Wage and Hour Division, which you've done. That is the right thing to do. Go ahead.
Right. Now, my I-140 is approved and 6 months over. My H1B is valid until December this year. So, with all this said, it doesn't make sense to me to continue with this employer in any case. I'm still looking for project and H1B. But my question is, yesterday I filed the WH4.
Good.
Now, should I leave the country and go back, or should I assume that they haven't even said that we are terminating your H1B, so I can't even ask them, okay, book my ticket. They are just saying go back to your country. They are just saying that.
Hang on. Did you tell the Department of Labor that they have not offered you a one-way ticket back to your home country?
Yes, I wrote it in the paper, yeah.
Good. Now let's look at the practical implications. We can look at the worst case scenario and the best case scenario because there's no way to be 100% sure how it's going to play out. The 3-year and the 10-year bar makes me nervous. There's no question about it. Under the USCIS and the Department of Labor policy, if an employer wants to fire an H-1B employee before their time, they've got to do 3 things. 1, they've got to tell you, you are fired. 2, they've got to say, here is a one-way ticket back to your home country if you want it. And 3rd, they've got to inform the government, please revoke her H1. Okay? The problem is, what if they have not done 1 or 2 of these things, but later on government agrees with them and revokes retroactively? Are you accruing or have you already accrued unlawful presence? These questions are actually unanswered. Because as a practical matter, what I have seen is, if I remember the regulation seems to suggest that the revocation should become effective retroactively from the date the request was filed. So if they have asked for revocation on July 1st, but the revocation is granted in November, it will be effective from July 1st. See my point? And it's very difficult to predict when they filed because we have no connection with these guys. We don't know when they filed, when did my unlawful presence begin. So difficult to predict. Okay? What you can do is, I'm trying to see, I don't do these visas, these victims of crime visas. What are they called? U visas. I wonder if you could be covered by something. You should check with some lawyers who do the U visa kind visas if you could be considered to be a victim of a crime, although there's no crime here per se, not yet. It's definitely a regulatory violation. But I don't know what to tell you. On the conservative side, this is the best case scenario, or what I would do. I would want to leave within 180 days after a point of time. What is that point of time? Probably when I suspect or I know they filed for the H1 revocation. Okay, so you can probably send them an email saying, aren't you going to offer me a one-way ticket back to my home country? And also we have all these problems with the W2, what's going on? Because if they fire you based upon that, you might have some additional protections. There are whistleblower protections under the new rules. Let me take a quick look at it. I'm looking at my own blog entry on the I-140 rule, which also contains the H1 grace period rule. So, can use AC-21 to start working. Now let's see when the grace period is available. It's available if ported to a new employer. Isn't there a whistleblower protection here? Must be used consecutively, cannot be used again, not available. I don't know the law. This is a fairly intricate issue. I don't know off the top of my head. I want to see if you are protected by whistleblower protections, because if they, let me take a step back. Let me explain to you what whistleblower is. If I complain against the employer and the employer fires me because I complained against them, that is what is protected. You shouldn't be fired for that. That's called a whistleblower protection. If you blew the whistle on your employer or complained against them, they shouldn't fire you. Okay? Question is, how do we bring in whistleblower protection in a case like this? And the answer is, I just don't know off the top of my head. I can't think of. Yeah, go ahead, miss.
Yeah, additional information on that, and I'm not sure how how true it is, but before filing WH4, I called up WHD office twice.
Right.
And the second time, which was day before yesterday, when I called, there was an Indian over there, and given that, I mean, the native tongue was same, he was nice, and he explained me certain things that in this case, he didn't say whistleblower, but I think he was talking about the same thing, where he says that the problem will be that if they file a case against you for any kind of fraud or anything, you will have to hire an attorney, and that will cost so many $1,000, and the attorney can say that since this WH4 complaint was filed, the lawsuit which has been filed should be paused. That's what you can do. That's what he said. Now, he also said that, I mean, he was like very positive about everything, that okay, we have given so much of money, so and so back for these candidates, those candidates, all those things he said. And then he also explained that okay, you can give your email, we are very nice, and you can tell our staff to contact by email, all these things, all that, like a rosy picture he created. So it's okay, I mean, right now to have this rosy picture, I'll get some kind of a consolation. But the problem is, I still don't understand that the further process he explained that you will have an interview after you have filed this thing. So should I wait for that?
No. Hang on. If that is your question, that is an easy one to answer. You do not have to be in the United States for the government to pursue your claim further. You can let them know, look, I have a status issue. Unless you can help me with the U visa or some other kind of visa, I have no choice but to go outside and try to come back in when I have another H1. You can contact me in India. This is my email, this is my Skype, this is my phone numbers in India. They can do that, and they can actually recover your money and send it to you as well. I do not believe that's an issue. I know cases where people went back and they got their checks anyway. Okay. Look, I got to run to the next person. I've got one more person waiting. Good luck with this. I know it's a difficult situation to unravel. Unfortunately, unless I look at the regulations and spend some time on it, I wouldn't know all the answers offhand. Okay? Good luck to you.
Sure. Yeah.
All right.
Thank you.
Bye-bye.
Thank you.
Okay. So the last question for the day is from Texas. Texas, go ahead, please.
Hello, Rajiv. This is Arjun. This is the follow-up question based on today's question I asked. It's question number 6. Thanks for excellent service. I or older.
Right.
So, and I'm talking to a person in India, and looking.
No, I have, sir. You don't have to repeat the question. I see it in front of me. I know what the question is. So just ask me the follow-up. Yeah, ask me the follow-up.
Oh, okay. Actually, I saw a little bit, a few minutes late, so I missed the response.
Yeah, see, I'm not going to repeat it either. You're going to have to wait for the recording.
Yeah.
Okay, I've answered your questions completely.
Okay.
Okay, so please, if you have a question and you want follow-ups on that, please log in on time. I'm not going to repeat my answers. Okay?
Oh, okay, sure.
All right.
Okay, thank you.
Bye-bye. All right, folks, this is it for today. I'll have Monica post the recording. I'll see you again in 2 weeks. Always a great pleasure to talk with all of you. Take care. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.